We have been working, and Chris obviously and her team has been instrumental in doing an assessment of our office in the past few years. We have really, General Wyrick has been working very hard on, trying to develop alternatives to incarceration. Historically, I think our office has been very good as it relates to suppression, meaning prosecuting and getting jail sentences for violent offenders. But we started to focus attention on lower level crimes and alternative approaches, starting with a community prosecution program.
So we've had in Memphis for many, many years, as I'm sure all of your jurisdictions do, community policing. A couple of years ago, we added community prosecution, parking career prosecutors out in the precinct, working with law enforcement, working with the community. The next logical step to us seemed to be this community justice idea. And I know many of you involved in this meeting today already have restorative justice-like models. We've taken ideas from many of you on the phone and involved in this conference today and tailored them to what we need in Memphis and Shelby County. We have a very high violent crime rate, we have a large caseload, and we have a high poverty rate in Memphis and Shelby County. So the community justice piece seemed to be the next logical step. And we'll switch to the next slide. What we've done is, the people that are going to be involved in it obviously are the defendant, the victim, two key players in the process. The panel will consist of 3 members of the community. There will be a community justice ADA assigned to each of our vertical teams. I think I heard Ray telling you guys that after Chris finished her year-long assessment of our office, we were able to switch to a complete vertical model. And so each of the vertical teams will have a community justice ADA. And then we have staff in our office that for years has been involved in the schools, and we're going to pivot them and assign them to this community justice. So they are non-lawyer advocates who will be support between the panels and the courts. Obviously the victim will have to consent for the case to be handled this way, and the defendant will have to agree for the case to be handled in this way. We can switch to the next slide. I know we're on a time crunch here, and I'm sorry to be.
Okay, yeah, no worries. When you said court, what do you mean by court?
Well, these cases will be in court. So these, unlike many of you guys on the phone and on Zoom today, we don't have pre-charging authority. So law enforcement makes the case, they make the arrest, they issue the misdemeanor citation. We get to court the next day, and then we evaluate the case. So all of these cases will start out in the court system, and then we will screen every new case. Our prosecutors will be trained on screening these at arraignment and looking for 18 to 26-year-old defendants charged with either misdemeanor vandalism, misdemeanor theft, or non-intimate partner domestic violence assault. We've designed a score sheet that we are contemplating using. We're just going to have to see what comes from that. What we don't want to do is get so small a population of offenders that there's really no impact. We also don't want to get so large a population of offenders that we don't have the resources to handle it. So we're kind of playing around with that right now and looking at cases as they come in to see how large the eligible pool will be. And we may end up expanding the age frame, and we may end up saying, we'll open it up to other misdemeanor offenses. We just need to see. Next slide. This is a map of the Shelby County area, and so what will happen once the case is screened and we determine that someone is qualified, our advocates will then get busy working with the panel and identifying a hearing date for the defendant and the victim to appear, and then getting information to the panel regarding the case, the affidavit of complaint, the arrest history of the offender. Those types of documents that the panel is going to need to make an informed decision on how best to handle and what sentence, quote unquote, to pass down to the defendant. And then next slide. Once that hearing gets set, our office will be the only contact with the victim. We are being very, very careful and sensitive to not wanting to re-traumatize or add issues to victims who have already been impacted by crime. So it's important to us that communications between the victims come from our office and our office only. The panel members will not be reaching out to victims. Victims will be allowed to attend the hearing, obviously, and we will encourage them to do so. If they don't want to, or if for some reason they're not able to, they will be able to fill out a victim impact-like document that will be read to the panel and will be made part of the hearing and the decision by the panel.
Amy, if I could just interrupt. When you talk about the hearing, this is not in a courtroom. This is a non-judicial function, and the panel are non-lawyers.
That's exactly right. We've had about 80 or so citizens in the community apply already to be panelists. We are working through those applications right now. What we want to do is put at least one panel in each of our 9 different Memphis Police Department precinct areas, but we don't want them to be in the precincts. They're not, the panel hearings are not going to be at the courthouse. What we want to utilize are our partner faith-based, use the churches, and they will hopefully be willing to open up their doors and allow us to have these panel meetings within the safety of the church. I see a question from Ken in Indiana. Yes, the panelists are going to be trained, and we are working on building that training program right now. There are, as I mentioned, we've stolen ideas from probably many of you in the conference today. There are training programs, some that last 4 days. There are training programs that last a day. We are building that right now. Hopefully, we're going to partner with a local university that's going to come in and train mediation and conflict resolution to the panelists, and as well as our office will be involved in that training to just kind of give them a crash course on the criminal justice system and respecting victims, our Victims' Bill of Rights, and those types of things. All right, next slide. So with this initial session, it will be, like I said, in a church. We're also very mindful of security. So we're going to work with our local law enforcement and see if they will provide some type of security at the location for the hearing. The 3 panelists will meet. They will decide each night who their facilitator for the evening will be. The facilitator will be responsible for getting the conversation going, for kind of setting the stage, explaining to the offender and the victim what to expect. And then they will have a conversation. We want this first session to last no more than an hour, and listen to the offender ask kind of a script of questions about why they did what they did, what's going on in their life, what some of the issues are, and then hear from the victim as well. The impact of the victim. Is there restitution involved? What would the victim like to see happen as an appropriate resolution? Each of the panel members will be members of that community. So we are geographically assigning panelists according to where they live. The panel will decide cases where the crime occurred, so that there is that aspect of community restoration, and that the community is having a say in what the quote-unquote punishment should be. Next slide. I mentioned the facilitator and then this restorative discussion. So we've talked about those things. And then we're putting together a resource map, a resource directory, because what we want to avoid, we don't want to micromanage, obviously, what these panelists decide and how these panels function, but we also don't want a panel deciding, hey, this guy needs to go to prison for 18 months. You know, we want it to be a restorative sentence, something that is helping the defendant so that they get out of the criminal path, and something where the victims feel that they have been heard and that their needs and concerns have been addressed. So we are putting together a resource directory for these panels to have, that is filled with all of the great agencies that our community has and all of your communities have, that we rely on every day already to do this type of work. But whether the offender indicates that they need alcohol and drug help or mental health or whatever the need might be, job skill training, high school diploma, there will be that list of proven, established organizations in town that we can look to pass the baton and work with these offenders. Next slide. And then there will be follow-up meetings after that initial meeting to check on how the offender is doing. There will be, that's where our non-ADA support staff will come into play to help keep up with these cases, make sure these offenders are doing what they are been asked to do and what they've signed a contract indicating that they will do. That's also something that we're going to build into this, a document that sets out what is expected of the offender. The offender will sign it, the panelists will sign it. We will advise, these are some great questions you guys are asking me. The defense attorneys will be allowed to attend if they want to. There will be defense counsel on each of these cases just by virtue of the way our system runs. And so at arraignment date, the offender will be told to get an attorney, and then we will work with the attorneys to say, hey, your client appears to be eligible for our community justice program. Why don't you talk to him or her about signing up, and let's handle it that way. So defense counsels can be present at the hearing, but we really don't want them to have a role. Part of the contract will indicate that anything and everything they say at those hearings cannot be used against them later on. So we want the offender to feel comfortable and free to speak openly and freely at that panel discussion. But then the follow-up meetings will be just checking on status. How is the offender doing? Are they attending classes? Are they doing the things that they contracted to do? This is not limited to first-time offenders, and that's one of the things that we're kind of looking at right now as we gather the data. The score sheet that we designed originally would have excluded offenders if they had a certain number of prior felony convictions. But what we're finding out, probably because of COVID and the fact that our law enforcement is just not making arrests like they have in months past, the pool of eligible applicants that we have right now is very small. So what I've asked the group to do is to go back and check dockets next week, take away that age requirement that I talked about, open it up to any age. And then also let's take away the score sheet and let's just see what happens. That may yield too big a crop, and we've got to whittle it down a little bit. But we're not going to limit it to first-time offenders, mainly because obviously with some of these individuals, what we're doing with traditional methods perhaps isn't working, and perhaps this is something that we could actually see some positive results from. If there are issues and the offender is not, according to the panel, has not successfully completed the program and what they promised to do, then we will have the ability to pick up the charges and prosecute the offender back in court. So the case will kind of be just held in abeyance on our judges' dockets until they work through the program. If they are successful, there will be a graduation that the panel will help run and take part in, and then we will dismiss their charges and expunge them from their record. And that may be, I don't know if there's another slide after that or if that's the end of it. But yeah, that's the conclusion of the CJ restoration. Hopefully it will all be more good endings than negative endings, and this ability to have the charge dismissed and expunged permanently from their record.